Well, hello everyone. Hopefully the right buttons have been pressed and you can see me and I can read your questions. I am Lior Samfiru. I'm the employment lawyer. And if you're watching me now, you've joined my live Q&A session on employment law. I'm one of the founding partners of Samfiru Tumarkin LLP. We're the largest employee side law firm in Canada. We operate in Ontario, in BC, and in Alberta. And I'm, as I said, an employment lawyer. And why am I here? Well, I'm here to solve workplace problems. I'm here to tell you what you need to know about your job, about your compensation, about your rights, vaccines, or termination, or severance, harassment, mistreated, constructive dismissal. You name it, now is the time to ask your questions so that when we turn off our computers, we feel better. You feel better. You know what to do. You know what to say. So if you have a question, if you were struggling with a workplace issue, you have an ultimatum, or maybe you've lost your job, maybe you're sitting at home on a leave of absence, ask your question. Find out right now what you need to know. Type it in. I will see it and I will answer it, and you can walk away with that knowledge. Let me give you some other contact information before I get started with answering questions. If you want to connect with me off air, if you actually want my help to do something for you, my team, all you do is you go to employmentlawyer.ca. Again, it's employmentlawyer.ca. That's our website. You'll see website, beyond the website, you have email address there, phone number there, forms there. You can connect with me directly and my team through employmentlawyer.ca. You see that address below me. So take advantage of that. Don't hesitate. Reach out to me. It's not just about asking questions today. I can't actually represent you. I can't do something for you here beyond answering questions. To actually get me to work, to do something, connect with me through employmentlawyer.ca. That said, let's get started. I'm going to start answering questions. You have time, type in your question. First question of the day on Facebook from Lani. My kid was postponed a year for not taking vaccine at U of T. Can we fight it? No, you won't. Unless they change their mind, you won't be able to do much. This is not an employment issue, obviously, but if the university has decided that, here's what I mean you can't fight it. You can file a human rights complaint, and you may win that, but that's going to take a year and a half. By then, it doesn't really matter because you'll be back to school in any event. So as a practical matter, you're not going to be able to do anything. Again, these types of things take time. So in a university situation, even if you win, it's not going to help. Next question from Tammy on YouTube. My employer let me go while on doctor-supported sick leave, claiming I was not on sick leave and therefore they do not have to pay severance. What can I do? Well, if you're let go while on sick leave, of course you have to get paid severance. The fact that you're not actively at work when you're let go doesn't deprive you of severance. You get severance as if you were still working, but it's even more than that for Tammy. If you're let go because you're sick, because you're off on a medical leave, that could potentially also be a human rights violation. So not only are you entitled to severance, you're also potentially entitled to other damages, to human rights damages. So what you need to do, Tammy, as soon as possible is you want to connect with me. Connect with me and my team right away. You can do that now. You can do that today through employmentlawyer.ca. Again, employmentlawyer.ca to connect with me. Good question from Tammy. Continuing to answer questions. But are coming in, so take advantage, guys. Next question from Jeanette on Facebook. Are employers allowed to force vaccinations with policies? Well, this is the question that we've answered thousands of times over the past number of weeks. So it's not a question of are they allowed. They're doing it, right? You can't call the police and stop them. So if your employer gives you an ultimatum that you lose your job unless you're vaccinated, you will lose your job. If you're not vaccinated, you can't physically stop them, but your employer is going to have to pay you severance. That severance could be as much as 24 months pay. Now, your employer is not going to do that. They're not going to say, we're letting you go and here's your severance. They're going to say, we're letting you go and we're paying you nothing. But that's where I come in. It's my job to make sure you get what you're owed, because legally they have to pay you severance. So can they tell you to get a vaccine and let you go if you don't? Yes, they can, because you can't stop it. but it's a wrongful dismissal if you don't get your full severance. So, Jeanette, it's an issue of severance if you've been let go, or even if you've been put on an unpaid leave. You want to call me right away to connect with me again, employmentlawyer.ca. Next question on Facebook from Corey. If you are a salaried employee, when you have an appointment, are they allowed to take hours off? And if so, do you get overtime if you're on salary? So, yes, if you're not working, if you take some time off, unless the company has approved it, then yes, they can reduce your pay because you get paid to work a certain amount of hours. And you do get overtime. So depending on your province, for example, in Ontario, overtime is paid after 44 hours a week, and that applies to salaried employees as well. So you get time and a half for any hours over 44 hours. Different provinces have different rules. In Alberta or in BC, for example, it's either 8 hours a day or 40 hours a week. But yes, you absolutely get overtime if you're a salaried employee. Yes, no question. Next question from Raj on YouTube. If all the federal mandates are removed, what happens to the people who are terminated for just cause without severance? Do they stand a chance to get their jobs back or at least severance? So first of all, there's very few federal mandates. The only federal mandates right now are for people in transportation, okay? And for those that work for certain government departments. There's no other federal mandates. But in terms of people that have been terminated, no, they're not going to get their jobs back, and they're not going to get severance. If you were let go because there was a mandate at the time, even if down the road that mandate gets removed, there's no legal requirement to pay you severance. Now, if you've been put on an unpaid leave, if your employer doesn't take you back, then you get severance, okay? But again, keep in mind, there is no federal mandate except for a very small number of employees. For those joining us, first of all, welcome. My name is Lior Samfiru. I'm the employment lawyer. I'm one of the partners at Samfiru, Tumarkin LLP, and I'm here answering your questions live on Facebook, on YouTube, and you have some time, so ask your question. Next question comes from The Dreamer on YouTube. If you notice an employee doing something wrong at work, whether it's big or small, how long do you have to discipline them before you would deem to have accepted it? That's a great question. You have a small window, I would say, usually within a week or two. If you go longer than that, you're going to be considered to have accepted it, or clearly it wasn't a big deal. So the sooner the better, always, for sure. Next question from JC 2004. Generally speaking, how much does it cost to go through a contract for a new hire? Probably right around $400. Next question from Tyler on YouTube. My company has implemented a mandatory vaccination policy. They may let me go on February 28th due to me not getting the vaccines. They have stated that by giving me notice that they will not have to pay severance. So very good question. So the notice that they give you counts towards your severance. So if they give you in writing 30 days notice that you're going to be let go, that 30 days counts towards your severance. So if you're owed 6 months severance, but they give you 30 days notice, then they only have to pay the difference, which is 5 months in that example. So it's a question of how much notice that they gave you. So Tyler, if you want to find out how much notice / severance you're owed, easy. All you do is you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You see the address below me, and you use our severance calculator tool. It's free, it's anonymous, it takes you 10 seconds to use it, and then you can find out how much severance you are owed. So if you go through that, Tyler, and you determine that you're owed 8 months severance, you deduct from that the amount of notice that you've received, and that's how much severance I have to pay, okay? So go to pocketemploymentlawyer.ca. By the way, any of you can use that. You can use that now if you lost your job, if you've been put on an unpaid leave, if you're worried about losing your job, if you're curious, check out our severance calculator at pocketemploymentlawyer.ca. Probably the first place you go to if you lost your job or want to know how much you're owed. All right, let's see. Next question from Tammy on Facebook. I work at a hospital in the housekeeping department, and we were forced on an unpaid leave. Is this legal according to our union? Okay, so if you're part of a union, then only the union can answer your question as to whether it's legal or not and what can be done about it. And as a general rule, anything we talk about on this session, anything I talk about, only applies to non-union employees. It does not apply to you if you're part of a union. If you're part of a union, only the union can help you, and different rules would apply. So only to non-union. Next question from VS 2015 on YouTube. How long does an employee have to be an LTD before an employer can terminate them? So there's no time limit. You can be on LTD as long as you need to, so long as you have your doctor's support. Now, at some point, your absence could become so long that it becomes what we call a frustration of contract, where the company can just end the relationship. Usually, you need two things for that. You need to be gone for about 2 years or more, and number two, there needs to be no likelihood of ever coming back to work. But beyond that, there's actually no time limit, as long as you're working and getting better to hopefully return to work. So Julie asks if you have any offices or meeting places outside of downtown Toronto. So the nice thing right now is, especially in a remote environment, is we're meeting and speaking with people across the province, across the country. So location is irrelevant. If you are in Ontario or in BC or in Alberta, we can help you. There's nothing you need to worry about in terms of location. Just contact us and we'll set it up. Next question on YouTube from Sunny. Well, I'm currently the president of a company. I just started a family business and I'm the majority director and shareholder. My business is in completely separate industry than the company I'm the president for. I am not I'm not involved in the daily operations of the business I started. Are there any complications with my current employer? Am I obligated to inform them that I started a business? You should inform them, okay? You should inform them because it's something they need to know. Even if you say you're not really involved, it's impossible to be the majority shareholder and director if you're not involved. They need to understand. I would tell them that you're involved or that there's this business, but tell them that number one, it doesn't impact your job. And number two, your hours are not going to change in any way, shape, or form. That's much better to do that than they find out later, they make assumptions, and then they could decide to let you go. So honesty in this situation is by far going to be the best policy. Okay, let's see. So answer that. Next question from Alexander on Facebook. If you have a documented injury on the job and your employer let you go, can you get severance as well as human rights violations? Yes, potentially. So certainly you get severance. That goes without saying, not even a question. In terms of a human rights violation is if you were let go because of the injury, even if it was partially because of the injury, and it doesn't have to be the only reason, but even if it was part of the reason, then you can absolutely get human rights damages. So Alexander, if you've been let go, you want to contact me right away so we can get to work and get you the compensation that you're owed. To connect with me right away, easy to do. All you have to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. So next question is from Ashley. I'm on medical leave of absence because of work harassment from my boss, and my doctor does not want me to go back because of a toxic environment. So, okay, and then you're saying, can my work let me go? I'm not sure I understand because you're saying you don't want to go back, so I'm not sure why you're asking about whether your work can let you go. Ultimately, you can always leave, but the question is, are you going to be compensated? If you can show that you were harassed, that it's not just your word against someone else's, then it's a constructive dismissal, which means that even though you choose to leave, they're going to have to pay you severance because in the eyes of the law, it's as if they let you go. So the question when it comes to harassment is always, how do we prove it? How do we establish it? Do we have anything in writing? Do we have a recording? Do we have witnesses? How do we establish it? If we can establish it, absolutely that's a constructive dismissal, meaning if you don't go back, then you're owed severance. Now, the other thing is why don't you go back, if you can't prove it right now, and simply say in writing, I've been harassed, I've been bullied, and I expect that to stop. See if the company does something about it. If they don't, you may have a good case at that point for constructive dismissal. Mike asks on YouTube, can I sue the Canadian government for the vaccine mandate? No, you cannot. Next question from Helen on YouTube. What is a normal process to deal with a wrongful dismissal caused by reprisal and then unfair appraisals? Well, what can you do? It's easy. You just contact us. There's nothing you're going to be able to do on your own. You contact us and we get to work to make sure that we deal with it. Obviously, I would need to know more to be able to have a strategy how to deal with this, but there's nothing you're going to be able to do on your own, unfortunately. You have to contact us. That's simply going to be the answer. And Helen, to contact us, again, very easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. You see it right below me, so you can do it that way. Next question is from Julie. Can a company that is not federally mandated use the federal mandate rules for exemptions? I'm not sure I understand the question, but I think I do. Ultimately, if a company decides to let you go because of the vaccine, it doesn't matter how they get there. But if the company decides to let you go because of the vaccine, they have to compensate you. So you're asking, can they do that? Well, they can because they are, right? You can't physically stop them. Remember, when we talk about employment law, there's no employment law police that you call 911 and they go to your employer and say, no, you can't do that, employer. We're stopping you and we're taking you to jail if you are. No. So there's no employment law police, meaning if an employer does something they're not supposed to, all that means is they have to compensate you. So unless there's a government mandate that requires your employer to have you off work, unless there's that government mandate and they choose to let you off work, they have to compensate you. It's as simple as that. And if you are in that situation, if you've been let go, if you've been put on a leave, you have to give me a call so we can get to work and get you both EI and severance. Next question from Jordan James on YouTube. I have been with my former employer for 8 years and now placed on a 4-month unpaid leave. Am I entitled to my severance pay so I can move on and get a new job? Absolutely. Well, you said you've started a case with us, so you already know the answer to that, Jordan. I'm not sure why you're asking. Obviously, you know the answer because you have a case with us already. Next question is from Zoe Dash on YouTube. Upcoming BC Human Rights Tribunal case. Should I transcribe my handwritten notes going back to 2019, which I recorded the harassment, bullying, and gaslighting I endured from my former director? I would need to know much more about your case. I would need to understand what was the harassment, what do those notes show, how relevant they are. So you need to contact me to do that. I will say this, if you're going to go before the Human Rights Tribunal without legal representation, you're doing yourself and your case a disservice, okay? The likelihood of you being successful when the company is going to be represented by a lawyer and you're not is not high. So that's going to be a big mistake. Next question on YouTube from Raj. I'm on an unpaid leave due to the company vaccine policy. If I'm hoping for my job back, is it best to wait a little to see what happens before contacting a lawyer? Well, you have to decide between getting severance and trying to get your job. There's only those options. So if you're insisting on trying to get your job back, there's no point contacting a lawyer. If you want to just get compensated, that's when I come in, right? So you have to make that decision. They're mutually exclusive. Jeanette asks, if mandates are lifted, can employers still force employees to get vaccinated? Again, I'm not sure you're using the word force appropriately, because an employer can have a rule, right? And if you don't comply with the rule and they let you go, they have to pay you. So government mandate or not, an employer can still say, to work here, you have to be vaccinated. And if you're not, they're going to have to pay you. Just like an employer can say, we've decided that to work here, you have to wear a red hat. And you say, I don't have a red hat. I don't like red hats. So too bad. That's our rule. That's not because there's a government mandate. It's simply our rule. If you don't wear a red hat and they let you go, they'll have to pay you. Same thing with vaccines. So forget about what the government's doing. If the employer decides not to have people working because they're not vaccinated, all that means is they have to compensate the employees. Next question from Tammy. What happens if the company does not disclose what type of leave they put you on? I'm not sure I understand the question, Tammy. I don't know what you mean by that. Next question on YouTube from Videoland. Is an employer required to accommodate a religious exemption? Where does the Ontario Human Rights Commission stand on this? So if there's a legitimate religious belief that's supported by a religious leader in your community, then yes, an employer is required to abide by that. Now, it's not enough for you to say it's religion. You need a religious leader to corroborate that. So a rabbi, a minister, a priest, whoever the right person is in your religion. And if your employer doesn't, then yeah, there could be human rights damages. And that's really how the law works. If there's a legitimate human right there that needs to be accommodated, the employer has to accommodate. So very good question. By the way, for those joining us, welcome. My name is Lior Samfiru. I'm one of the founding partners of Samfiru, Tumarkin, LLP. I'm live here answering your questions about employment law. Still have a few minutes, guys, so ask questions. Okay, next question from Tyler on YouTube. What would be considered official working notice, as I have not been directly notified by a general company-wide email, but a general company-wide email has been sent. Does that count as working notice? If that company-wide email is clear that you will lose your job on a certain date, then it's good enough. Even if it's not necessarily addressed to you specifically, but as long as it's clear that it's going to impact you, then it's good enough, but it has to have a specific end date. If they simply say, you're going to lose your job in the near future or at some point in the next 3 months, that's not effective. That's not good enough. But if it says you will lose your job on March the 1st, then it is good enough. Okay? Next question from Julie on Facebook. I work for a car manufacturer and have a shoulder injury from 12 years ago. We are building a bigger vehicle, and I was asked to get a functions of abilities assessment done. I'm worried they will make me work against my restrictions. Any advice? Well, they can't make you work against your restrictions. So the advice is make sure you get a doctor's note or that form completed outlining what the restrictions are. If they ignore it, you call me. I'll give them the right kick in the pants because legally speaking, they absolutely have to accommodate you. So I would not worry about that. Okay, I really wouldn't. Brandon on Facebook. I am off on LTD. My employer would not give me any of my LTD information until I threatened to get a lawyer. I'm still waiting on my claim decision, but my employer and Sun Life both tell me that they are waiting on paperwork from each other. And this time I have been through extreme hardship. Is there any grounds for compensation since they wouldn't give me LTD information for so long? Yeah, potentially there could be. So happy to talk to you about that. There could be damages for their conduct and the suffering, if you will, or hardship that it imposes on you. So if you want to chat about that, happy to do that, Brandon. You can reach out to me through employmentlawyer.ca. Next question from Roseanne. Will these mandates and company policies regarding vaccines and testing end as soon as governments say so, or will the companies continue with it? I have no way of knowing what companies will do, right? No way. Each company will make its own decisions, so I can't tell you what a certain company will do. It's going to be up to them. Next question is from VS 2015. Can you be on COVID leave because you're afraid of catching COVID at work, even with proper safety measures? In other words, can you decide not to go to work? Unfortunately not. If you decide not to go to work, even though your employer is doing what it's supposed to, you're going to be considered to have resigned. Next question from the Dreamer on YouTube. If an employee comes back to work after the vaccine mandate ends, would they have deemed to have accepted the unpaid leave, even though there is no more mandate? Well, obviously, if you go back to work, then you've accepted the leave, right? I'm not sure I understand the question. If you were not to accept it, you wouldn't have gone back to work. You would have treated it as a termination. So if you go back to work, obviously you've accepted the leave. Tanya on Facebook, can I get severance from the casino if I still have not been called back to work since the beginning of the pandemic? I've been there 23 years with no union. I'm still receiving benefits. Yes, you absolutely can. If you want to get severance, you can. And after 23 years, depending on your age and position, it could be anywhere from 18 to 24 months of severance. So if you want to do that, Tanya, let's talk. Connect with me as soon as possible. I wouldn't wait on this much longer through employmentlawyer.ca. And by the way, you should understand that if you've been off since the beginning of the pandemic, the 2-year limitation period is going to expire next month. So you want to contact me immediately. Okay, employmentlawyer.ca. Next question from Jessica on YouTube. I provided my employer with a doctor's note for accommodation. I tried their temporary alternative shift for accommodation and it didn't work. My accommodation notes are clear, but my work is requesting more information from my doctor and are refusing my request unless they can speak to him. Can they request this information? Well, obviously the devil's in the details here, Jessica. What I need to know is, I need to know, what did your doctor say previously? The new role they gave you, how was that different? Why you weren't able to do it? What other information they're trying to get from your doctor? So I would need to have that information in order to be able to speak intelligently about that. So please feel free to contact me through employmentlawyer.ca. Mike says, doesn't the vaccine mandate violate the Canadian Charter of Rights and Freedom? So you're talking about government mandates. There has been no court decision that has ever found that it violates the Canadian Charter of Rights and Freedoms. So it's purely speculation. I don't decide if it violates the Charter. You don't decide. Only a court can decide that. There's no decision like that. So as we speak today, no government vaccine mandate violates the Charter. And it will never violate the Charter unless a court decides that it does. And that has not happened, okay? So, and of course, the Charter does not apply to what your employer does. It only applies to what governments do. Okay, let's see. Take a couple more questions. Some questions about unionized employees. Again, talk to your union. I really can't answer those questions. Okay, so Zamco has a question about the U.S. I can't really answer that. It's not an employment question. I may be caught up here with questions. So guys, if you have other issues, questions that come up at any time, you would reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca to connect with me off air. I'll take one more question here and then we'll call it a day. But after I'm done, I hope that you still do the right thing and you connect with me so we can have a private discussion. So the last question today will be from Belinda on YouTube. Does the 2-year limitation period you were talking about start from the first time you were placed on an unpaid leave? What if your employer extended your leave time or put you on a second leave? So it starts from when you were put on leave the first time. Now, if you went back to work and then you were put on a second leave, then the limitation period starts from the beginning of the second leave, okay? But if you were put on a leave, even if that leave was extended, as long as you didn't go back to work, the limitation period starts running the day of the first leave. So for many people, that would have been around mid-March of 2020, which means in March of 2022, next month, that limitation period is going to expire. So very important to remember that. Guys, that's the time that we have for today. Again, my name is Lior Samfiru. I'm the employment lawyer. I was here for the last 30 minutes answering your questions. A lot of great questions as always, so thank you for that. I'll be back next week, and other colleagues of mine will be back later this week as well to answer more questions. But don't wait for any of that. If you have questions, issues, if you actually need help to do something, connect with me as soon as possible. We have a whole team across Canada at employmentlawyer.ca. Guys, thank you very much. Enjoy the rest of your day, and we'll talk soon.